honesty. In these cases, most of the time, don't we both bring in paid experts who give completely different testimony and ask a jury to believe one of them?
I have heard of things like that happening, yes.
Okay, so perhaps with an expert who's looking at the facts and the data, that may not be as constructive, and it may be one of the reasons that you don't see them in PTAB proceedings, but isn't cost also driven up by live testimony?
You know, this controversy came up when I was still at the agency, and the conclusion was at the board that people very rarely ask for live testimony. These are paper-based cases based on patents and printed publications. You know, the priority either reads on the claim limitation or not, and it doesn't matter if someone looks you in the eye and seems very confident that it's one way or another. It ultimately depends on what the references and disclosures show.
Thank you, and thank you for your indulgence, Mr. Chairman. I yield back.
Thank you, Mr. Issa. We will next turn to the gentleman from Wisconsin, Mr. Tiffany, for 5 minutes.
Thank you, Mr. Chairman. I yield to the gentleman from Kentucky.
I want to thank the gentleman from Wisconsin. I want to follow up on the live testimony request. Ms. Ellison, do you think that's something the judges would like, or the petitioners or the defenders?
I think some of the parties would like to see that happen more often.
That's what I've heard. I have one inventor who said that the judges, like there was a dog barking in the background when her case was being heard in front of these PTAB judges, and she thought it was extremely disrespectful and didn't convey the weight and the gravity of what was happening, that she was possibly losing her livelihood. Mr. Bright, you've talked about how when there's no good presumption of validity to a patent, there's less deal flow, there's less investment into those technologies. But I'd like to ask you, and I'll ask you also, Mr. Rogers, you know, the U.S. military relies on secure communications, technology, equipment, satellites, networks, and do you think that it's possible that PTAB has contributed to the lack of development of that here domestically, or that possibly China's taking advantage of the fact that we have a weakening patent system due to PTAB, and that we don't have enough investment in things that could provide more national security?
Yeah, I'll defer to the experts about the actual security technology and what is involved in that. But what I'll say is the overall trends that when we look at the venture capital data and where they're making investments over the last several years, they have not been investing as much in those technologies as they have been in other shorter-term technologies and things that are not in that cybersecurity area or in that security, national defense security area.
Let me ask you that question, Mr. Rogers. You've worked in this field for the government, is that correct?
I have.
And so do you think there could be a problem here in the fact that we don't have the presumption of validity that we should have in our patent system?
Absolutely. I know from my experience that that's the case because when you are going to disrupt a big legacy technology industry like ours, for example, there's embedded software, there's next generation hardware, there's application software, there's all of the support infrastructure around that. We build and manufacture all of that in the United States. It's a massive investment. And unless you have that quiet title to be able to protect that investment isn't going to be made. And we've seen over the past decade, venture capitalists fly exceptionally fast to what is the app that we can back and flip and sell as quickly as possible. And that isn't the strategic technology that is needed for national security.
So, and China clearly has a national security policy of trying to develop those things domestically in their country. Do you think they are advanced enough or smart enough to take advantage of our patent system using PTAB to tilt the table?
Absolutely. It's another tool in a very long strategic effort. And it's no coincidence. The former head of software for the Air Force resigned, and on his way out, he said, "We have lost the war on artificial intelligence technology, but we just don't know it yet." That's happening rapidly right now.
That's troubling. I'd like to ask unanimous consent to submit for the record an article called China Hijacks U.S. Patent System to Steal American Inventions. I don't think they even really have to steal these American inventions. They just have to take away the desire or the ability for people to invest in these inventions that are critical to national security. Did you have something to add, Mr.
Yes, if I could, Congressman Massey. Another issue, besides the one you raised, is the lack of a presumption of an injunction against an infringer. So the fact that that was taken away 15, 16 years ago now allows a Chinese company to assume that even if they did appropriate somebody else's technology, they're going to still be allowed to use it.
Isn't an injunction the biggest thing that deters somebody from infringing? I mean, if you merely get caught and have to pay the royalties that you owed before, that's not much of a disincentive to steal technology. But isn't it true that most inventors and investors really do rely on injunctions?
Yes, that is correct.
That's because if you're a big company, that's the biggest threat you have, is that you have to quit shipping something that you've already marketed. And just continuing my unanimous consent request, I asked unanimous consent to submit this article. It was in usinventor.org, for the record.
Without objection.
Mr. Chairman, I
So
yield
ordered.
back.
Thank you. Gentleman from Arizona, Mr. Stanton, is now recognized.
Thank you very much, Chairman Johnson. Thank you for your leadership, and thank you to our panel of outstanding witnesses for taking the time to join us today. In my home district in Arizona, it's a hub for high-tech manufacturing, and patent issues are always top of mind for many of my constituents. More broadly, patent issues are of vital importance to our nation's economy and our competitiveness in the global market. So I'm grateful that Chairman Johnson has made it the focus of today's hearing. You see, we have long understood that our patent laws stoke the fires of America's innovation. And from the cost of prescription drugs to our investment in manufacturing facilities, Americans are affected every day by the complex and technical issues surrounding our patent system. In recent decades, as our economy and technologies have modernized, it has become increasingly clear that Congress must also act to ensure that those patent laws, which have benefited all Americans, from the small inventor in their garage to the cutting-edge researcher in their university lab, that those laws are modernized as well. That's why 10 years ago, through the American Invents Act, Congress established the Patent Trial and Appeal Board, commonly known as PTAB, to offer an alternative patent review process to expensive district court litigation. We all understand that attorney's fees and trial court costs can be very, very expensive, and that court calendars can change and legal matters can drag on and on. By establishing PTAB, Congress has intended to offer parties a speedier, more technical, and more efficient way to challenge the validity of patents that have already been issued by the USPTO. In the years since the AIA was enacted, issues arising within the patent system have shown us that it may be time for Congress to act again. Big pharmaceutical companies have too often gamed the system to delay lower cost generics from hitting the market. So-called non-practicing entities have continued buying up patents and asserting them on behalf of investors against American manufacturers. And the so-called NHK FinTIV rule has allowed PTAB more discretion to deny petitions for review when there is a parallel district court lawsuit already filed. So as we examine the patent space for potential legislative action, I appreciate the input from all of our witnesses today. But my first question is for Mr. Mittal. Mr. Mittal, as one of the lead Senate staffers who worked on AIA, can you give us some insight into the purpose of the discretion that was baked into the bill? Was it to provide flexibility as the AIA was being implemented, or did you see it evolving into what is now the NHK FinTIV rule?
Thank you, Congressman. The agency was intended to have some discretion to manage these proceedings. There were, under the previous system of inter partes re-exam, the agency felt it couldn't even impose a page limit. And the thinking was it should have the same authority to manage these cases that a district judge does to manage their docket. However, agencies are purely creatures of statute, and agency discretion is always bounded by law. I'm not a critic of all of these discretionary policies. 325D is statutory. General Plastic, I signed off on myself when I was acting director. But when the statute does things like set a deadline in relation to district court proceedings, the agency doesn't have authority to shorten that deadline. The agency is obligated to follow the law.
Mr. Stanton, you need to unmute.
Thank you very much, Chairman. My next question is directed to Mr. Pushparaj. I understand that you work with many startups in Silicon Valley. In my home state in Arizona, we are fortunate to have many small business startups as well. Even though PTAB proceedings cost less than district court litigation, they are still expensive, and I imagine it's not where small startups want to be spending their money. Can you explain how PTAB helps small businesses, even if they don't file many IPRs?
So first off, I want to dispel this notion. A patent is not invalid because the PTAB said it's invalid. It's invalid because it's invalid. As a startup, I am faced with, and I'll be blunt about it, non-practicing entities. There are many non-practicing entities knocking on our doors. And there are questions about whether we get VC funding because we're not able to file patents. There's more an issue of whether we're in business. VCs want to fund companies that are in business, whether we make a revenue, whether we are actually in business. And these threats, multiple threats from non-practicing entities over patents that are practically silly, threaten us because every litigation, spending millions of dollars in every litigation is indeed threatening to our existence. So PTAB, an ability for us to be able to, it's not the cheapest forum in the world, but it is an option for us to be able to still manage expectations on cost and time to be able to resolve these issues. When we have a pending litigation that exists for 6 years at a time, that also staves out the cost that VCs want to put in because there's pending litigation. The timeliness is as important as the ability for us to go to a forum and resolve it. So yes, startups, PTAB have indeed had a positive impact on startups in this manner.
Thank you so much. I yield back, Mr. Chairman.
Thank you. I will now recognize the gentleman from Oregon, Mr. Bentz, for 5 minutes.
Thank you, Mr. Chair. Thank you all for your testimony. It's extraordinarily interesting. I question for Ms. Ellison. You referenced the fact that the judges in the PTAB process are giving more, quote, deference, end quote, to initial patent issuance. Do you think that should rise to the level of a presumption?
I think it effectively has risen to the level of a presumption. So under the recent case law, if a reference has been considered by an examiner during original prosecution, then the petitioner bears a burden of showing that there's been some error that's material to patentability. And so I think that's been an effective way of giving more deference to the original prosecution and brings us a little closer to Mr. Massey's proposed gold-plated patent.
Right. Thank you. And since I want to hear a little more on the other side of this issue, I yield the balance of my time to Ranking Member Issa.
Thank you. Thank you very much for yielding. One question I want to resolve. The reason that we allow third parties to submit information that may tend to reduce or invalidate a patent is one of those reasons from original legislation to be consumer interest, that every person is affected by a patent and the cost that it brings on. Would it be fair to say that most of the PTAB proceedings that began with companies in China or outside the U.S. had to do with having been challenged in similar court cases or accusation of infringement?
Yes, I think according to Saurabh Vishnubak's study, over 85% of these cases are brought by parties that have been sued for infringement.
And wouldn't it be fair to say that if you receive a threatening letter, that you have a choice? You can do a DJ and go right into Article 3, or you can do a PTAB if you think you have prior art. And someone might argue whether you have standing, but wouldn't it be fair to say that it's cheaper on everybody if you've got prior art?
Yes, and sometimes when you get that letter, you can't go to court. You won't have standing. Other situations that come up where someone hasn't been threatened, but they see a patent out there that reads on a product they're planning to develop, and they do a clearance IPR just to test, am I allowed to develop this product or not? You also see the proceedings used in customer suit cases where someone's customer is sued, but if you don't have an indemnity agreement with that customer, you typically can't get standing to even challenge the patent. And finally, just quickly, Unified Patents is a substantial client of the firm, so take what I say with a grain of salt. But if you look at the cases Unified is bringing, they're bringing it against some of the worst actors in the system, people who are harassing small businesses, quickly seeking quick settlements. I don't think we would want those cases to go forward.
Now, there's been a lot of talk about stays. For all of you, would you say that a single stay in a federal court, even if there are multiple PTAP applications, would be appropriate? In other words, if there are serial applications, should that be allowed to further delay an Article III judge going forward? Or should we begin to tighten up the amount of time that an Article III court could stay based on a process in the PTO? I mean, it's an opinion, but it's one that I think we all want to know, because it certainly, for those cases where there have been repeated ones, should we try to make sure that we establish some procedure to limit delay?
You know, I don't want to consume more than my fair share of time, but not all serial challenges are created equally. Sometimes it's the same party challenging. In that case, these days, you'll probably be cut off by General Plastic. Sometimes those serial challenges are because the patent owner sued multiple people in a staggered series. Whether to stay a case, the district courts just need discretion. Sometimes not all the claims are instituted. Sometimes they are. It'd be nice if the district courts exercise that discretion in a more consistent manner.
Mr. Capos.
Yeah, thank you, Congressman Isa. But to come to the question directly, I would say that there does need to be some limit to staying of district court cases in your hypothetical where there are multiple petitions. Otherwise, the patentee, never has an opportunity to get finality and quiet title.
Okay, and one for Mr. Pushparar. I'm sorry to mess up your name, but in your experience, the question of whether a patent has been examined or re-examined properly relative to when a patent holder begins to assert what they say it means, have you seen a huge difference in what appears to be prosecuted before the patent, the PTO, and what later is brought before an Article III court case?
So oftentimes, the resolution on validity is dispositive to a party being able to resolve. And this is true on both sides, as a plaintiff or a defendant. Having certainty that a patent is in fact valid has seen in firsthand experience ability for parties to go and say, yes, we will settle, here's licensing demands. And the reverse is also true. Having this position that a patent is in fact invalid prompts both parties to arrive at a faster decision, be it licensing or a settlement that just parties walk away from the lawsuit. So having this ability and having a first resolution from a PTAB, which is the cheaper, faster alternative, does in fact make a big difference in parties having quicker resolution.
Thank you. Thank you, Mr. Chairman. We yield back.
Thank you. Chair will now recognize the gentleman from Louisiana, Representative Johnson, for 5 minutes.
Thank you, Mr. Chairman. It takes on average 30 months for a district court patent case to get to trial, whereas every IPR by statute has to be completed within 12 months, as has been discussed. Additionally, patent litigation typically costs several $1 million to handle, whereas IPR costs several $100,000. But the IPR process only assesses the validity of a patent, which means that litigants are still required to go to district court to bring an infringement action or other claim related to patents. So this means that a single patent could have to go through both the IPR and the federal district court process. So my question is for Ms. Ellis or Mr. Rogers, maybe both of you, do you believe this dual system works well in practice, or should we consider maybe expanding the claims that can be considered via IPR?
I think, Congressman, it's an excellent point that you made. We filed our case against Cisco in 2018. It's now 2022. There's likely many years ahead. And when the point of a patent for a small company is to be able to break down the barriers to enter a market, well, at what point can you actually do that? So for the patent owner, it becomes an exceptional existential problem if you actually intend to participate in the market.
And Ms. Ellison, do you have thoughts on that?
So I don't favor expanding the bases on which IPRs can be brought. We do have PGRs that are available of course, within a limited time period. And I think the legislation that led to IPRs and PGRs struck a reasonable balance in that regard between the two proceedings. Sure, there can be both IPRs and district court litigation, but I think practitioners and parties have come to accept that. I don't think that we should get rid of the IPR or PGR system in its entirety because it serves an important function, in particular for entities that don't currently have Article III standing to appear in court.
Very good. I know a big complaint that patent holders have against the IPR process is that opponents can file multiple petitions against the same patent. So it seems logical to me that once a patent has been deemed valid by PTAB, it shouldn't any longer be subject to scrutiny by that board. But let me move to another subject, Mr. Pushparaj and Mr. Bright. I wonder if you could tell me how PTAB and the IPR process either benefit or burden small businesses. I know there are currently several pieces of legislation between the House and the Senate that are up for consideration, and I know one of them has been introduced by my good friend, Mr. Massey, but I wonder about your thoughts on that, the burdens or the benefits to small business.
I've stated this before, not having a forum to be able to quickly resolve issues, especially with the numerous patents that are asserted against us by non-practicing entities, does heavily burden small businesses, the very threat of existence to small businesses such as ourselves, tech startups, where you have an app, it is out there in public view, then there's 10 patents being asserted against you. And in firsthand experience, again, I've seen the presence of PTAB have an impact to the number of claims asserted against us by non-practicing entities. And that is an important effect on small businesses.
And Mr. Bright, your thoughts?
Yeah, so I'll just give a perspective from a medical device company to get a more realistic example. So it generally takes us 8 to 10 years to get a product to market through the FDA and ready to be sold. It then takes generally another 2 to 5 years after that to even reach profitability. And so it takes tens of millions of dollars, sometimes hundreds of millions of dollars in order to get through that entire phase. And once your patents are out there, if somebody sees them and knows that you're working towards that goal and you are worried about the threat that they will be able to take out your patents and undermine your further investment in it, it does create a stress in the operating environment of the company and in its investors. So you do have to be quite mindful and protective of it.
Very good. I've only got 25 seconds left. I just want to thank all the witnesses for your expertise. This is obviously a really important set of issues. I'm grateful, in particular, for Mr. Eisen, Mr. Massey, and their expertise in helping our side at least guide through all this. And Mr. Chairman, I thank you for your time, and I will yield back my remaining 7 seconds.
Chair thanks the gentleman. And the chair now recognizes the gentleman from Wisconsin, Mr. Fitzgerald, for 5 minutes.
Thank you, Mr. Chair, and I know we're getting into the area where some of this stuff might be a little redundant, but I certainly believe in strong property rights, and one practice that has evolved out of PTAB is particularly concerning, which is the serial petitioning, which has been brought up numerous times already. After the filing of multiple petitions against the same patent owner or even the same patent, given the high cancellation rates of PTAB, a company with multiple petitions can suffer obviously severe damage to its stock, particularly if it does not have resources to go against some of these big tech companies. At the same time, to be able to make large investments in plants and equipment, a lot of manufacturers right now need to be able to obtain accurate and reliable review of the patents that they are asserted against them. And we're also seeing, obviously, some of the shell companies that are able to purchase broad, low-quality patents, such as company MPHJ that had the, quote, scan-to-email technology, quote, unquote, technology, and effectively holds companies hostage for some of these huge paydays that we're seeing. So it would be to everyone's advantage, I think, if you dealt with those patents quickly. At the risk of burning through my entire 3:30, I'd like, is there any way anybody would like to comment on that? I certainly would welcome that. just describe any changes that could be made to the current system to strike a balance, which are obviously competing goals. And Mr. Kapos, if you wanted to start.
Yeah, thank you for the question, sir. I would just say the clear and convincing evidence standard that a number of us have mentioned would be a sure way to hold petitioners accountable. Further guidance through Congress modification of the FINTIV rule that's been talked about would help with the issue you've raised to avoid serial petitions, still leaving some flexibility for the PTO to be able to, I say, beg off or decline to take a challenge where a challenge has already been taken before, where a district court has already made a judgment, where the Federal Circuit's already made a judgment.
I can just add a couple of more ideas if it's okay. Yeah. So I think that if the PTAB would prohibit multiple petitions on overlapping claims, that would help. Also, I think that the petitioner should be required to disclose all the entities that are behind the petitioner, and all of those petitioners should be made privies to the case, and that once a decision has been made with respect to the petition, whether it's denial or institution or whatever it is, that all of those parties are then subject to that ruling.
I think that the points made by Mr. Kafos and Mr. Bright are excellent. And the only additional perspective that I'd offer is that we've gone very hard over in this balance of equities to the users of this system who are largely trillion-dollar firms. And the legal budgets here are likely a small fraction of a quarterly dividend. And to get balance back in the system, we need to think about patent owners.
Yeah, I'll just add, if as long as Congress is considering changes, I might suggest adding the issue of 112B, patent indefiniteness, to IPRs. Nowadays, you occasionally get these decisions where the board is asked to review something as obvious, and they say, we have to decline to institute the petition because the claim is indefinite, and I don't know what it reads on. And that doesn't really benefit either party. That's obviously a black mark on the patent, and the claim is left forward. If the board's doing that analysis anyway as part of the institution decision, you might as well let them reach the final decision. It's a decision on the papers. So I'd recommend adding 112B to the grounds that can be raised in an IPR.
I'll just add, I think it's important for the PTAB to maintain discretion when it comes to instituting trials. I think no one wants to see abuse of the patent system, and so limiting to some degree the number of petitions that can be filed makes sense. But on the other hand, having hard and fast rules that say, oh, only one petition should ever be filed on a patent, arguably goes too far, particularly when you could have potential petitioners who are completely unrelated, and the second person doesn't get their day to be heard. Thank you.
Gentleman's time has expired, and we are now at the conclusion of this hearing. The gentleman from Kentucky, Mr. Massey, is recognized for the purpose of introduction of items to the record. Mr. Massey.
Thank you, Mr. Chairman, and thank you to all the expert witnesses here. I have two articles to submit. One is called How Google and Big Tech Killed the U.S. Patent System by Michael Shore and IP Watchdog. And the second is called Big Tech Sticky Fingers Are Still at Work in Washington by Adam Mossoff. He's a patent expert at George Mason University.
Without objection, so ordered. And we are now at the conclusion of the hearing today. The witnesses, I thank you for participating. Without objection, all members will have 5 legislative days to submit additional written questions for the record or additional materials for the record. And without objection, this hearing is now adjourned.